I'm Angenette Levy. I hope that wherever you are staying warm because where I am, it is really cold and it is starting to snow. It could be treacherous. So I hope you're staying safe. It's been another semi-busy week in the world of crime, sadly. But we are here to talk about things that happened. Specifically, we're going to talk a little bit about the Tepe murders in Columbus, Ohio, in my home state. Also, I'm going to touch a little bit on the Pike County massacre case. There was a decision that came out from the 4th District Court of Appeals in that case. That case has been sitting, collecting dust for years now, and there's been a big decision that impacts Billy Wagner's case. So we'll touch on that at the very end. I don't know if we'll get to the latest in Coburger tonight. Maybe we'll do that another time, but there were some pictures that came out this week in the Idaho Murders case, a horrific case, and it's caused quite a stir, and there are some new reports that have come out as well. So want to thank everybody for being here tonight. If you're watching on replay, thank you for watching on replay as well. And remember to drop in the comments where you're watching from. I'd really appreciate that. City, state, and country. Also hit that thumbs up. And subscribe, please, to support the channel. Would love to have you as a subscriber. Thanks to the mods also for being here tonight. Do it without the mods. They are busy week here. Michael McKee. It was a short work week, of course. We had a 4-day work week, but Michael McKee, the man accused of murdering Monique and Spencer Tepe, the husband and wife who lived at the house in Wineland Park with their 2 young children. He was brought back to Columbus, Ohio. The Franklin County Sheriff's Office went to Illinois, picked him up, brought him back. We knew it was coming. We knew it was happening, but they did it pretty quietly because the notifications about his transfer did not go out. And I think that was by design, of course. They wanted this to be done quietly and safely. And he was brought back here early last week, not on Monday, of course, because it was a holiday. But he had been indicted late last week. And those were 4 aggravated murder charges he was indicted on, plus an aggravated burglary charge. Not really a shock with those charges. But I want to bring in somebody who is familiar with this case. We have a special guest tonight. He worked at the Columbus PD for years and years and probably has some knowledge of, I'm sure, how they handle their homicide cases there in Columbus. So his name is Jay Fulton. He's a retired police detective at the Columbus PD, and he's been retired, Jay, I think you told me since 2020, right?
That's correct. I retired in December of 2020.
Yeah, so you've been retired for quite a while. Well, thanks for coming on. I'm appreciate it. I know you're probably staying inside tonight because it's cold up there. Has the snow started up there yet?
We have not started getting the white stuff yet, but
Okay.
they've promised us 7 to 10 inches or some such thing. So I will I'll wait and see.
Yeah, we're hearing anywhere from like 8 inches to 14, which in my mind could mean like 2 to 5 or like a little. So we'll wait and see overnight what that means.
I probably would have stayed in regardless.
Yeah, right. It's freezing. It's freezing cold. I went to the grocery earlier and it was awful. So tell me if you would, when you first heard about these homicides with Monique and Spencer Tepe, you know, every homicide is terrible, but some are different than others, you know. This happened in an area where the North Short Posse, I know, used to be pretty big, the gang in Columbus. But this is a husband and wife asleep in their beds. It's really every family's, you know, every person's worst nightmare. You're sleeping in your bed in the safety of your home. Your children are tucked in their beds. It's over the holidays, you know, the kids are down the hall and you're shot to death in your bed. I mean, there's really nothing more horrific than that. What were your thoughts when you first learned about
Yeah, absolutely. They don't have the victim profile, if you will, of a homicide victim. This is a very rare type of occurrence in Columbus, practically anywhere. You know, they just didn't live a lifestyle that lent them to put themselves in a situation where they might become victims of homicide. And again, it's a rare home invasion type situation. The early reports were that there was no signs of forced entry. So with this type of victim, I think you immediately, as an investigator or detective, you start thinking about, you got to look at their lives and who in either one of these victims' lives would have reason to cause them harm. And you would get that information from the interviews with close friends and close family, because these are the people that are likely to have heard mention of if they're having a problem with someone, if there's been a problem, if there's been a problem at Spencer's work, if there's been a problem in the neighborhood, if they're complaining about anything, that's going to be information that the detectives are going to want to follow up on immediately, because their lifestyle didn't certainly put them in danger.
No. And from everything we could see, no. It doesn't seem like their lifestyle would have put them in danger. What, from what we know now, I interviewed Monique and Spencer's brother-in-law, Rob Misla. He told me, and they were being very careful about what they said in the beginning. Rob was, but he told me that, Monique's family and friends from the beginning, they said, you have got to go talk to Michael McKee. He had made threats to her during her marriage. She was not shy about talking about him. She was afraid of him. He was emotionally abusive. I mean, it seemed like everybody thought this could possibly be the guy.
Yeah, absolutely. And that information is valuable to the detectives, and it would have been a starting place anyhow. Once again, you have people that are living a lifestyle that doesn't lend them to be victims of this type of violent crime. It's the nature of the crime is very personal. So you are going to look at somebody, there's no reported theft. There's no reported ransacking of the house. The children are left alive in the house. It's very targeted. And so obviously ex-spouses or ex-relationships are going to be at the top of the list for any detective to begin with. You back that up with the fact that you're getting reports from family members of one of the victims that she was afraid of this relationship. She had been threatened, and these are things that are going to be followed up on within the days within hours of the discovery of the bodies.
And it appears they followed up. I had heard from some reliable sources that they did go talk to McKee early on in the investigation, and that he was cooperative, offered an alibi. But obviously, as the investigation progressed, we got to where we are now. So what were you hearing, or what do you think happened?
Well, they detectives went to Chicago. They were able to determine his whereabouts, and I don't know if it was in Chicago where the contact with Mr. McKee within days of the discovery of the bodies, or if it was in Rockford at his business. I do not have that information, but yeah, and I'm sure he would have been expecting that visit, because I'm an ex-husband, so he's ready for that one. And I don't know. I don't have privy to what was said. I know there was a discussion. I know they did go there and meet with him. And I think you want to establish that statement. At that point, you're not Mirandizing him. It's a conversation that you're having with him. He's not in custody. It's a voluntary type interview situation. So you explain to him, we want to establish your whereabouts, and so we can clear you and move on to find out who's responsible for this. And that's how you present yourself as a detective. And you get whatever information you can. And, whether if you can prove those things then to be false during the course of your further investigation, that puts you at an advantage as a detective that, you can see that if he was lying to us about A, B, and C when we talked to him back in on the 1st of January or, thereabouts, it shows you which direction you might need to continue to go in. At the same time, concurrent to that, you're downloading all the video from the area, the crime cams, the Ring doorbells. You're following up on that alley man video that I'm sure you've been privy to. The traffic cams in the area, what cars are moving through there. It's a residential area, and in the hours that they were looking at, there's not going to be a ton of traffic. It's in those early hours of the morning, there's not going to be a lot of movement. So it's going to be license plate readers and traffic cams are going to be able to single out vehicles, and you're going to be able to identify those vehicles. And I think that that really led them back to Mr. McKee.
Yeah, it's my understanding. I mean, you said it. They went to Chicago, whether it was Chicago or Rockford. They talked to him. He did not say he was in Ohio. He said that he was, he gave an alibi that he was not there. He certainly didn't say he was at their home at the time of these homicides. No. He said he was in Illinois, and he gave an alibi, and the alibi started falling apart.
They were able to prove he was not. It was in fact in Ohio, and on 4th Street or in the vicinity of the house.
The license plate readers. I mean, those things are everywhere these days. And the surveillance cameras, maybe not everybody has their camera working or whatnot, but even the city crime cameras, they have those all over the place in different.
They're everywhere now.
Yeah, they're everywhere. So, I mean, you can be put somewhere they can track you pretty easily. It might take some time just to piece that all together.
Sure, and that's what the time was. Yeah, that's what the time was. I'm sure they were working from the first hours to collect this footage, but somebody has to go through that footage, and somebody has to account for the vehicles that are showing up on the license plate readers, and that's a constant job. So while he never came off the list, they had the detectives had volumes and volumes of digital evidence to look through. They're also going to be doing geolocating on cell phones in the area, what phones were active and what phones weren't. And then subsequently, somebody's financials can put them on the move in Ohio if you stop and get gasoline. I mean, these types of things will all be followed up on. But they were able to see that, and they may have known that before they even spoke to him. But the important part is you go over there and you get him on, tell me something, and then they were able to work backwards from there.
These things, as I said, take time, and they have these analysts. I'm assuming at Columbus PD, this is how it works, that, it's not just the detective sitting around trying to piece together video. They actually have, analysts who sit around and look through the video and things like that. Is that how that works at Columbus PD?
Absolutely. Crime analysts, from my understanding, is they pulled them from every, they're assigned to certain areas or they're assigned to certain crimes. That they pulled all available analysts off of every thing that they were working on and went to work on this case. So countless hours of time went into cruising through these videos. Everything from people's Ring doorbell cameras to the actual crime cams that are up in the neighborhoods. They were downloading all the information that were captured by the license plate readers. So they were assembling a list of everybody they could count that was in that area, in that window that they had established, that time window that they had established.
Yeah, and that's the too, and nothing I did not think that. I mean, part of me thought it was a little strange at how quiet they were being, and part of me thought, okay, maybe it's due to the fact that this happened. I mean, it happened over the holidays, right? So it
It
happened on
did.
December 30th in
Yes.
the early morning hours. It's literally the holidays, and maybe they had some good leads. And when you have good, solid leads that you're following up on, you don't need to go public. Maybe you don't need to engage the media and have a big press conference because you've got some solid stuff that you're working on and you don't want to jeopardize the investigation. Looking back, I think that's how I look at it. It felt a little strange that there wasn't something that went out immediately, but do you think that
I think you're
what
exactly
exactly
right. You're
yeah.
exactly right on that, Angenette. They had they had a place to start. I think the releasing of the video of the alley man was done was a twofold thing there. They knew that they believed this person to have been involved, and they wanted to engage the people, particularly in that geographic area, to redouble their efforts to check those cams, people they might not have got to, to kind of bring the public in as a partner in this investigation, and also as a pressure valve to stave off local media, because when you're working and you're working towards something, you don't have time to address the media. The detectives certainly don't have time, and everybody's got a job, and so that's a little pressure release valve. This gives the media something to report. They kind of go away, and you can continue about your business. And I believe that that was the only thing that was really released. They released the fact that there was no forced entry, but they kept quiet about it and they kept it close to the vest. And I think that led to some really good results, because when they made their second trip to Chicago, they were able to obtain some very critical and valuable, what's been reported to be critical and valuable evidence as they continued their investigation into Mr. McKee. And if you'd had a lot of information leaking here in Columbus, that evidence might have been disposed of. If this person is following the investigation from Chicago or from Rockford on the internet, and finds out that there's a target on him at this point, maybe they don't recover what they have reported to be a firearm that matches ballistically to evidence that was recovered from the apartment or the residence.
I was impressed that it seemed like there were zero leaks. I mean, zero leaks in this case, and still, there have not been many leaks.
There's not. They're doing a great job. They're doing a great job. My hat's off to these guys. They were young detectives when I was an old detective down there, and they do good work. They're smarter now than they were when I was doing it. They have more resources in as far as this electronic avalanche of information, but they know how to go through it, and they know how to read it, and they've done a fantastic job, not only in the investigation, but in keeping that investigation amongst the team, and not putting out information that didn't need to be put out. And it's led to a very successful conclusion.
Jay, we have a question. Do you know if it's true that they went to the Chicago area twice before the arrest, or did they go up there just that one time, around that weekend of the after the homicides?
Yeah, my understanding is they went. Some of them may have stayed there when others came back, and then other people went back at the time of the arrest. So I think Columbus had a footprint in Chicago or the Chicagoland area for several days following the homicide, and then several days prior to the arrest and the execution of all the search warrants.
Okay, so maybe they had a couple of guys hanging out there, maybe surveilling him something like
I
that.
think we had some assistance. I believe the Columbus police had some assistance from some of their partners in the federal law enforcement arm as well. And I don't know about local assets, but I'm sure they were the folks in the area were made aware that this is what we're doing and this is what we're doing here. So that's a courtesy thing, and that's a safety thing, and that should definitely be done. So I'm sure people were aware, and they got assistance from other agencies, and that's and my hat goes off to those agencies too, because they didn't spill the tea either. So everything was kept tight, and it was executed flawlessly.
Spill the tea. Love it. So you brought up the federal law enforcement aspect of this. I confirmed with the ATF, with a spokesperson based in the Chicago area, that they indeed assisted with the arrest. And we know that NIBIN was used in this case. The chief said it in her press conference, that there was a link. So I'm trying to figure out, did the ATF assist because of the firearm aspect of this case and because of the use of NIBIN? Do you think that was part of this? Or, I just know they scooped him up at the Chick-fil-A or whatever. Yeah, the Chick-fil-A, which just really makes me, I giggle about that. Not because I think there's anything funny about this case. I don't. But this guy pulling out of a Chick-fil-A and he thinks, he's just got his, I don't know, maybe his waffle fries and whatever.
I guess, yeah, they said he went to their lunch. He went to lunch there every day. So I guess that's where that's how they knew where to find him. I think they probably knew that. I don't know. I think sometimes you can ask. I mean, first of all, he's crossed state lines. They have resources available to them that maybe we don't have, and we certainly wouldn't have in Rockford, Illinois. They can be requested to come in. I don't know if it had something to do with the fact that the firearm, because they recovered the firearm after the arrest, is my understanding. So I think maybe it was just a shout out for help, and then the NIBIN hit came after the search warrants were executed, which would have been, I think, post-arrest.
That would make sense. So the probable cause for the arrest was the surveillance footage.
Absolutely.
They were able to track him. And then I'm sure the license plate readers played a part in that too. And that was likely, it's a combination of that stuff. I think that was probably the probable cause for the arrest. I mean, it's as much stated it in that initial complaint.
Yeah, and that's what the arresting documents pointed to. The initial arresting documents that were filed on the initial murder was that the surveillance put him in the area, in possession of the vehicle, and then also continued electronics surveillance, put him in the vehicle, in possession of the vehicle, post homicide in the Chicagoland area. So that the vehicle was the main thing at that point. And then, that's probable cause. And now the search warrants have, I think, borne fruit. Certainly.
Yeah. Interesting.
They are reporting that the gun is a match.
Yeah, everybody, NIBIN is a I'm probably talking ATF, NIBIN. I'm using all these, like, ATF is the for those of you who may not be familiar, it's the Federal Bureau of Alcohol, Tobacco, and Firearms. That's relatively self-explanatory. NIBIN is like a national ballistics network where they can, it's used a lot to solve unsolved homicides, especially with gang stuff. It's my understanding, because if they can link a bunch of homicides together with the shell casings, and then NIBIN. I was going to do a whole separate thing on NIBIN, and we'll do that another time. I just didn't want to kind of like dive into that tonight, but we can dive into NIBIN another time. When I worked in local news in Cincinnati, I did stories with like the feds and stuff like that. Dave DeVillers was our U.S. attorney down here for a little while, for a minute. And NIBIN was used in some cases, and even used in local homicide cases. But for those of you who don't know, and I reported this on Crime Fix, but it was like, 1 or 2 lines. in my crime fix podcast over on Law and Crime. The Columbus PD sought out the assistance of ATF, Illinois State Police, and Rockford PD, and scooped up Michael McKee at the Chick-fil-A. So that's where he was taken into custody. So Jay, now let's turn to, I want to watch a little bit of this arraignment because now he's hired Diane Menashe. And I think, I know she's a very talented defense attorney.
Very talented.
And very talented. Is very well respected in the defense attorney community. And this was like literally the briefest of brief arraignments. So we're going to look at this. We're going to look at two different angles of the arraignment. And I want to look at this because this is, to me, classic Diane Menashe, because let me put her picture up here. She's a very good defense attorney. She's in, get out. I mean, this was nothing more than a formality. We knew he was going to plead not guilty. That's just how this works. And, that's what she did. So let's watch this. I pulled up WBNS's feed of this, and it was almost hard to find it because it was so short. It was like if you blinked, you were going to miss this arraignment. It was so crazy short. So we'll watch this and then we'll talk about it.
1 count of aggravated burglary, felony 1. Each of these counts come with a 3 and a 6-year firearm specification.
Thank you. Counsel, please make your appearance.
Thank you, Your Honor. Diane Menashe on behalf of Michael McKee.
Thank you.
Your Honor, with respect to the allegations, we would acknowledge receipt, waive reading, enter not guilty pleas to all counts contained therein. We would also waive bond at this time, although we certainly reserve the right to raise that at a later date. The plea of not guilty form has been executed and signed on behalf of my client. Nothing further.
Thank you, counsel. I've signed the not guilty plea. I'm signing the bond form indicating the bond has been waived. Anything further?
No, Your Honor.
Thank you.
Thank you, Judge.
Thank you. Next case, please.
Okay, so she's like, okay, he can sit there. We'll waive bond. No big deal. She may have a thumb drive with some discovery, but she probably hasn't even gone through it yet.
Please.
Good afternoon, Your Honor. Stephen Schott, Dan Leonard, Shayla Faber for the state. First case before the court, State of Ohio versus Michael McKee. It's 26 CR 253. There are 5 counts. 4 counts of aggravated murder, unclassified felonies, and 1 count of aggravated burglary, felony 1. Each of these counts come with a 3 and a 6-year firearm specification.
Thank you. Counsel, please make your appearance.
Thank you, Your Honor. Diane Menashe on behalf of Michael McKee.
Thank you.
Your Honor, with respect to the allegations, we would acknowledge receipt, waive reading, enter not guilty pleas to all counts contained therein. We would also waive bond at this time, although we certainly reserve the right to raise that at a later date. The plea of not guilty form has been executed and signed on behalf of my client. Nothing further.
Thank you, counsel. I've signed the not guilty plea. I'm signing the bond form indicating that bond has been waived. Anything further?
No, Your Honor.
Thank you.
Thank you, Judge.
Thank you.
All right, that was just another view of it. We got to actually see another view of that was like the courtroom footage from the actual Franklin County Court of Common Pleas. So I'm curious, obviously this is an arraignment, not guilty plea. We knew that was going to happen. She waives bond, but who knows? She could come back at a later date after evaluating some of the evidence in her mind and say, we're filing a motion for bond here, I don't know how much money this guy has, but he's a vascular surgeon. And if he's good with money, he should have, some cash stashed away. I don't know, but medical school is expensive. So I'm kind of wondering from a law enforcement perspective, from your perspective, Jay, I'm thinking to myself, you don't hire Diane Menashe unless you're looking to fight. That's how I look at it. I hire Diane Menashe if I'm in big trouble and I want to go to trial and I want to win. And she's had some big wins. I mean, the Husel case, she teamed up with Jose Baez. I'll put that picture up for a second. We covered this on Law and Crime, gavel to gavel. This was a big win for her with Jose Baez. So maybe he makes an entrance into this case. Also, Matthew Moore case, which I was going to play some of her opening statement from that in a little bit. She got that guy off. So, what is your feeling like if you were a detective on this case? Would you be like, oh, whoa, okay?
Well, I've worked with Diane on cases on the opposite side. She's an outstanding attorney. He's obviously gotten some good advice, and it could be based on Dr. Hussel's experience that he even came by the name. I don't know how he would have access to that knowledge other than in medical circles. Maybe he was aware of Diane's prowess. One thing about her is that she does have good, she is very good at client control. So he may be his idea now may be, I'm going to fight this. I want a bulldog, and I want to try this case. I want to have my day in court. Diane is going to evaluate the discovery, and she is going to evaluate the evidence, and she's going to have a heart-to-heart with her client at some point. If the evidence is it's what's being described, if there's a match on a firearm ballistically to the scene, it's recovered from his, I don't know, business car, home, wherever that evidence was recovered, and the electronic surveillance type items that put him in the area, and he's given a statement indicating that he wasn't. These are all things that are going to affect how Diane pursues this case. She's not going to, I don't think she's going to have to take some control of her client at some point and say, hey, look, we need to have a heart-to-heart here because I don't, what you're saying doesn't make sense. I don't know what he's going to tell her. I don't know, what he may tell her nothing, but as a law enforcement, it doesn't matter. You're going to continue to do, you're going to continue to work the case. You're going to continue to collect evidence. You're going to continue to follow up all the leads so that you don't give Diane, the things she can attack are the validity of the warrant. These are the kind of things that could cause a case to fall apart. But I think these guys and gals have been doing such a fine job that they're not going to allow those technicalities to allow anything to slip through. I don't think you can't worry about who's on the other side. There are a lot of good attorneys. He's picked a good one, but she's not going to. She can't perform magic. So you depend on the evidence. You depend on your team to continue to pursue anything that comes up. Obviously, if they've recovered the firearm, they say it's matched, they're going to be able to find out where that firearm was purchased. I think there's still a lot of electronic material that they're going through. Much like the Kohberger case, it's my opinion as a retired detective, he did not make one trip to Columbus, Ohio and execute this crime. I believe that his footprint is going to show up in Columbus, in that vicinity, on other occasions leading up to the homicide, practice runs or surveillance type activity. That's all going to be very hard to refute in court.
That's very interesting. Okay, so that would make sense because
he didn't come here one time. That's impossible. You don't go out and do this without, if he's thought about it for as long as he's thought about it, which appears to be about 8 years. You're not going to roll the dice on one shot to Columbus. What if they're not home? What if they're on vacation? You've got some knowledge that they are going to be there. And from, how do you know this from 8 hours away? You have to kind of develop what their schedule's like in your mind. You have to have, this is all part of the plan. So I believe ultimately they're going to be able to show that he spent more than one night in Columbus, or more than one evening, one early morning hour, that he has spent time here. and those things will come to light as the discovery process opens up. And at that point, as an attorney, you're bound to give your client a defense, but you also got to be honest with them. And if these things come to pass, then the honest thing to do would be to say, let's get in front of this and try and get you out of prison at some point in during the remainder of your life, and seek some type of arrangement with the state.
That's very interesting, because all of what you're saying makes perfect sense. But I guess I just look at this as, if I look at Diane Menashe as like a trial attorney. That's how a litigator, somebody who goes into court and fights for a client. So have you seen her? Have you been on cases where she actually did plead something out?
Well, I don't remember any specific cases that she's pled out. I have been cross-examined, so I have been on cases where we did go to trial. But yeah, I think she's an attorney, and she's going to work for her client to the best of her ability for client. And I think if you're a client that insisted that Diane try a loser, that Diane's not going to try a loser. And I think that she's going to try and exert the control over the client. And once again, this is based on my gut as much as anything, and my experience with attorneys that are just as talented and just as good litigators as Diane. They all are willing to go to trial if they've got a chance. But if there's a lot of cases that we don't have a ballistic match to a murder weapon, but we try the case. Now that's a different animal when you come up with a weapon that's ballistically matched. I think I agree 100% though, that his demeanor is, I'm going to try this. I believe the narcissist in this guy thinks he could fool the police when they showed up in the days following the homicides. He thought he could fool them with a story. He may try and fool Diane with a story. He may try and fool a jury with a story. But the evidence is going to speak louder than that.
Very interesting. Yeah, I look at Diane Menashe as a fighter. That's how I see her. Just having watched her, covering trials and having seen her in 2 other trials, she's definitely a fighter. But aggravated murder, these are the most serious charges you can face in the state of Ohio. I mean,
well, absolutely.
Premeditated murder, silencers, suppressors, the whole 9 yards. I don't know.
Again, in regards to that, I don't think that I've not seen this happen in my career, where they went back and filed a new charge, but they filed the murder charges initially. They came back and filed aggravated murder complaints, and used the fact that there was a automatic weapon, the code under the automatic weapon or suppressor, which they got the indictment from the grand jury. That tells me they found something during the search of Mr. McKee's home, car, or place of business that gave the grand jury probable cause to believe he used a suppressor. And the only thing I can imagine that would be that they found a suppressor, or paperwork indicating the purchase of a suppressor. These things are huge pieces of evidence in the pre-planning.
Yeah.
And to get those indictments, they presented evidence to the grand jury that one was used. And where they came upon that, it couldn't just be the absence of noise from
right.
There has to be something that would allow them to testify in front of the Franklin County grand jury that based on this is why we're asking for this. And based on finding one, that would be a huge piece of evidence.
I'll be interested to see if they think he purchased it, if it was, or whether he made one, because I've covered cases where people actually made a homemade suppressor and actually did a good job
Oh,
designing
absolutely.
and making them. So I'm assuming, I mean, I don't know what the allegation will be. And these are all, everybody, I want to be clear. These are allegations at this point. Michael McKee, as anybody in our criminal justice system, is innocent until proven guilty. We have a question here. Angenette or Jay, what's the advantage of not asking for bond? Sorry if this was asked already. Well, Jay, I'm just going to say she waived bond because this is 2 aggravated murder charges. She knows the judge was like, it's not even worth arguing about. I mean, because
normally when an attorney argues for bond, they say things like lifelong resident of. Well,
yeah,
you can't say that from, he's not a lifelong resident of Columbus, Ohio. They say lifelong resident. They say no criminal background. It's hard as an attorney to argue that he's not a danger to himself or the community if he's charged with these counts of aggravated murder. So, I mean, also, I don't believe Diane's had a chance to go over any of the discovery. So she doesn't really have a place to start arguing, that this is weak evidence. My client's being held. So she hasn't even had a chance to look at the discovery. So probably hasn't even asked for it yet because so there's no real argument for her to make at that time. And as you pointed out at the beginning, what's her goal here is to get him in and out of that courtroom with as little fanfare as possible. That's her fanfare comes in 9, 10, 12, 14 months if this thing goes into a courtroom. Right. She doesn't need the fanfare she doesn't need to make that any arguments until she needs to make arguments. And so she probably explained to him the likelihood of getting bond is very low at this time. We're not even going to ask for it. And,
the judge was, I mean, they could have said it's not a death penalty case, but they're not seeking the death penalty, but it's 2 counts of aggravated murder. They were either going to set an outrageous bond or no bond. I mean, so she's not even
you don't want your client walking around, even if he can make the bond, what's the headline? The bond's set at $5 million or bond's set at, now your client's in, the best thing that can happen for Diane and at this point is this thing to go off the news cycle, something else to happen. And let's just get the work done that we need to get done to prepare a defense. And let's keep this thing off the front page of the local paper. Let's keep it off the top of the 6 o'clock news. So we're not even going to address that. We reserve the right to do it at a later date. And that's kind of boilerplate for a case like this.
I agree. She's probably like, let's just get this hearing, not guilty. We'll revisit bond later. Maybe. Let's move on. I have a bunch of discovery to look through. I need to get to work and do the real work in this case. Okay, so let's look. I do want to look just here. I wanted to ask you before we look at the Matthew Moore thing, just the couple minutes of her opening statement in that case. Have you ever been cross-examined by Diane Menashe?
I believe so. Yeah, it's been years, but I do believe, yeah. And maybe she was a younger, and of course I was younger then too. A younger detective, and she was a younger defense attorney. It's been years.
We were all younger once.
Well, I was in the homicide unit and started in 2003. So I've encountered about all the lawyers, local criminal defense lawyers, and have a good relationship with most of them. I never took it personal. I mean, I understood the nature of the position I was in versus the position they were in. And I've formed lifelong friendships with a lot of the guys and gals that cross-examined me. It's not a personal. I don't take it personal. I never do.
Yeah, they have a job to do and you have a job to do. Oh, we have a question from Truth and Transparency. Good evening, Jay. Thank you for the super chat, by the way, Truth and Transparency. Jay, do you think the crime scene is compromised because of the wellness check? All citizens in house before the cops. Do you think that, or do you think, is that a concern?
Well, I think that, it's not ideal, but at the same time, it's not like you had an unknown person. I mean, those persons that entered that residence that morning and just made the discovery, they're not unknown to us. So you can take them aside, you can interview them. What were your actions? How did you get in? What did, and so you have a record of who that person is and what they did and said and saw inside that residence. Did you touch anything? I mean, those people will be available to serve as witnesses in court, and likely will made themselves witnesses in this case. So yes, it's not ideal, but it's not any kind of, I don't think it's a compromise unless they were in there and, somebody admits to planting evidence in there or something, and then you got a problem.
But one question I have for you, and I forgot to ask this earlier, how do you think that he got in? What do you think the theory is? Because they said in the very beginning, the cops did, there were no signs of forced entry. But of course, a burglary can just be entering a home through, the door could be unlocked and you're not invited, and that's a burglary. So how do you believe, how do you think he would have gotten in without forced entry? Because we could see there was an alarm system or a security system there. I assume too. I feel like everybody has cameras in their homes these days. I have cameras in my home. I don't really love it, but I have them. So how do you think he was able to get into this home and not show signs of forced entry?
Well, and this is going to be my theory, but I believe the detectives already know. They know how he got in, and once again, I believe they do know. I believe that will be something that comes out. But I believe, it's my belief, and I don't have this from anybody, that he defeated that lock. So once again,
picked it.
Well, it looks to be a digital or like a punch in the buttons type lock. But
gotcha.
If there's a lock made, that lock can be defeated. I pointed out on another show, they were able to burglarize the Louvre Museum in Paris. This guy, people, locks, my grandfather used to tell me, locks keep out honest people. He had a farm in Southern Ohio, if there's a lock made, it can be beaten. And I think we can all say that a guy that's had an 8-year grudge is a highly motivated offender. And whatever it took to beat that lock, whether it was surveillance of people coming and going from the residence and picking up the pattern, whether it was something he purchased off of one of these spy shop type things, some kind of magnet device or some kind of, they've got skimmers. So this came to my mind, we would get these alerts in Columbus. Don't use your debit card at a gas pump, because people would go around and install skimmers. Is there some kind of software that he could have accessed onto the Tepe's door that would monitor the keystrokes, and then he could come back and retrieve that, and that would provide him with the entry code? I'm just saying somehow he defeated that lock. I don't believe they left their door unlocked in that neighborhood. It's gentrified, but it's not there yet. It's still in a work in progress. There was no sign of force. They didn't find any broken windows. They didn't find any. So it's my theory, and I don't know what. I'll be excited to find out if that information ever becomes public. But I believe he defeated the lock, and he went there with the motivation. He'd been there before, I believe. I don't know how many times, but he did not just come here that night. So he did his research. He knew what kind of system he was dealing with. He's not a stupid guy. He's an inept criminal, but he's not a stupid guy. So that's my theory. We'll see how it plays out.
That's very interesting. very, very interesting that you think he, defeated the lock. That's a really good way to put it. Because there are many things that could have happened, whether he picked it, which brings a lot of memories back of the Pike County case. He could have picked the lock. He could have done the many things you've suggested. I just don't know. Charles, thank you for the super sticker. I appreciate that. Very, very sweet of you. Let's just look at a little bit of her. We'll wrap up this topic a little bit, but I want to look at a little bit of the Matthew Moore, Diane Menashe's opening statement. This was a case in which she won an acquittal. She was successful. Matthew Moore was accused of murdering his wife, and then putting her body in a tree. It was supposed to be a staged taking of one's own life. I'm being careful with the words I use here on YouTube. You know how YouTube can be. So let's just watch her a little bit. I think she has a way of relating to juries. This is what I remember of her. So we'll watch just a minute or two of this.
Good morning. Good morning. As I introduced myself yesterday, Diane Menashe on behalf of Matt Moore, my co-counsel, Alexander Petrello. The state, I just listened to them for about 30 minutes, and they told you their theory. Their theory is that Matt Moore killed his wife. Don't know when, but Matt Moore kills his wife, and then somehow gets her body into the wooded area where you walked yesterday and stages her death. And then I heard the state go on to say that their evidence will show how not just was he that sophisticated to figure out those two things, but he then also took great efforts to control the situation after May 24th and May 25th of 2020. Members of the jury, the evidence will show that the state's theory is based on speculation and inferences. It is not supported by the evidence. And simply, members of the jury, their theory doesn't make sense. Now, I know you were listening to the state's opening just as well as I was, and the judge has already told you that our opening statements are not evidence. They are just how we believe the evidence will unfold. But I say this, that in my 30-some minutes of listening to the state's argument, I noted that they didn't mention reasonable doubt. That is their burden. Their burden is proof beyond a reasonable doubt. And we talked about that in voir dire. It's their burden and their burden alone. And the judge has already given you the instructions of law, and he will again, which say, if the state fails to meet their burden, then the only appropriate verdict as to each of the three counts in this case is not guilty. And here's why I mentioned reasonable doubt and that they didn't mention it. Is because as the judge has told you, and as I talked about in voir dire, reasonable doubt is a doubt based on reason and common sense. And so I want to talk about this morning during my opening statement as to why it doesn't make sense that Matthew Moore, and I'll call him Matt, that Matt killed his wife, Emily, and then staged her suicide. First, members of the jury,
Okay, so they use the S word. I hope we don't get in trouble on YouTube.
What are you?
That word. We'll go back and maybe snip that out. But yeah, I think she does a good job. She's dynamic, but really, it's the state's going to have to prove the case. That's what it comes down to. It's the state's burden. That's how our system works, and they have to do it. I will be very interested once motions get filed in this case. And Jay, they've kept a tight lid on this. They really have. There really haven't been any leaks. I've gotten a tidbit here or there, but there's just been, there's been no leaks. I've gotten like a couple of nuggets here or there, and that's about it. So they have done a good job there, but it will be very interesting to see once motions to suppress are filed and all of this stuff, what the actual evidence is, the electronic evidence, the other, I think it's going to be a lot of electronic stuff we know that with the video stuff, the gun stuff. Defense attorneys love to attack the ballistics and say that it's junk science. Going back 20 years of covering criminal cases, I've been hearing about ballistics being junk science for forever. So I think that's probably what we will see a lot of in this case.
Yeah, she'll have her experts, I'm sure. Should this thing go to trial, like I said, and for every expert the state puts up there and says that based on these markings on this shell casing that was fired by that weapon, and they'll have their bona fides. I went to school here, I did this, I did that. And then the defense will call their own experts, say, that, like you said, that's junk science. But it's a, it's kind of a tit for tat there, but what the judge is going to instruct people as to what is acceptable or good evidence. This is going to be a circumstantial case. I mean, this is not a case where you're going to have an eyewitness that says that they saw this. So the evidence as it's collected and presented, and I think there's going to be a wheelbarrow full once they're done. I did believe it will put will make the hill very hard for Diane to climb, regardless of who prosecutes it. I mean, as long as they follow the rules and we don't, like I said, they keep these leaks from getting out before this stuff's all going to come out eventually. We'll all know, but there's a time where we'll know, and until that time, it'll remain somewhat a mystery to us. But I think the detectives know exactly what they're doing. One of the traps you can fall into is you don't follow up on all the other Crime Stopper tips that came in on this. I mean, they're going to continue to do that so that Diane can get up there and say, detective, you've zeroed in on my client within hours of finding these bodies, and you never looked at any other. We had reports locally that there was a neighbor or somebody in that neighborhood reported door knocks at an odd hour of the morning and called. So I'm sure they're following up, to eliminate those types of things. Anybody called in and said, I think my ex-husband did this, or my crazy uncle did this, they're going to follow up on those things just to close those doors, because those are all doors. And the main thing is, you get in there and you want to confuse the jury or try and present a, like the police had some kind of motive against Mr. McKee. I don't think, how can you establish that? I'm sure that was the first time that anybody ever met Mr. McKee. So, like I said, it'll be interesting to see, but she is a dynamic lawyer. And I suppose if I was in a jam, she would be at the top of the list of people. But once again, it's going to be the evidence that does the talking for the state. And I think there's going to be plenty.
Mm-hmm. Well, we will keep an eye on it. Jay, thank you so much for being with me tonight. I hope you'll
happy to join you.
Time as we learn more. It was so fun chatting with you, and I hope you're staying warm in C-Bus.
Yeah, absolutely. Thank you very much. It's nice to meet you.
Nice to meet you. Thank you. All right. That was Jay Fulton, retired Columbus PD detective, joining us. Very generous of him to join us tonight on Saturday night. Michael McKee being held right now without bail in the Franklin County Jail for the murders on aggravated murder charges, I should say, of Spencer and Monique Tepe. Just really awful guys, awful case. And we will be following it for you. I'm going to move on now to just briefly. I want to update you guys on the Billy Wagner case. And you guys know Billy Wagner, Pike County massacre case that I've been covering since April 22nd of 2016. My goodness. A horrific case. The Roden family, 8 members of the Roden and Gilly families murdered in cold blood in the middle of the night. Jake Wagner and his mother, Angela Wagner, pleaded guilty. They admitted to all of this. They testified against George Wagner. He is serving time in prison for that, 4 life sentences, or 8 life sentences, I should say. Case has been a bit of a hot mess. It's been a hot mess since the beginning, but now it's been even more of a hot mess. You guys probably remember the new judge, Judge Jonathan Hine. He took over the case back in, gosh, I don't even remember. I feel like it's been forever now. Late 2023, 2024, early 2024. It's just been nuts. And so he struck the death penalty, Judge Hine. I'm going to play maybe like a minute of this. Angie Canepa, the special prosecutor, got furious about it. He struck the death penalty from Billy's case. There's this weirdo plea deal. Jake Wagner said, I'll plead guilty to all 8 murders and testify against all of my family members as long as you take the death penalty off the table for all of us. I don't want to be put to death. I don't want my family and friends being put to death. And so it was kind of crazy. And so it's a weird plea deal. It's weird. The judge in this case is like, these cases are taking way too long. Judge Hine, he's like, these cases are taking way too long to make it their way through the system. Just strike the death penalty right off the bat. There's no reason to seat a death qualified jury. If Jake's going to testify, right? If he's going to testify and he's already testified against George, there's no reason for you to seat a death qualified jury. He's going to testify against Billy. He's going to sit up there and do the same thing. He's not going to renege on the plea deal. So the judge said, well, I'm not seating a death qualified jury. This is silly. I'm going to strike the death penalty. Angie Canepa had a fit. That's basically her leverage over Jake to make sure he testifies against Billy. Again, this is a wonky plea deal. Even Angie Canepa knows this has never been done before. I've talked to her about it. Okay. Like we've talked about it. So let's go back to this hearing. And I'm going to show you guys this real quick. She was fit to be tied during this hearing. Fit to be tied. Watch this, guys. This was back in, I feel like this has been taking so long. Ron O'Brien, he used to be the Franklin County prosecutor. He had just come on the case and he's literally sitting there like, what is going on? He came on to assist Angie Canepa. So I'm going to play this little bit where I think she kind of loses it here a little bit. And when I say that, I'm just saying she gets very upset.
The applicant on the wiretaps, I have familiarity with the case prior to being appointed. But based on what I know so far about the trial aspect, I don't have anything additional.
So here are the orders coming out of today's hearing. On representation by the state of Ohio, the death penalty specification is dismissed. The case proceeds without that specification. All of the defendants' pending motions are dismissed because most of them were focused upon the death penalty, and then also the lack of anybody prosecuting the motions. I tried to make a record a long time ago, tell me what you need to do. So for benefit of the record, it's not the judge didn't get his work done, as he wasn't given the work to do. So all your pending pretrial motions are gone. The death penalty specification is gone. The death penalty specification is gone. I'm not on the tip of the spear. I understand, Ms. Canepa, your dilemma. Only to compound the dilemma, will I now tell you that I'm going to proceed to sentencing in advance of trial on the other cases. So I'm proceeding to sentencing. I'm going to ask the court staff to have Angela Wagner, the other Wagner case, set for sentencing. I'm done waiting.
Okay, obviously, you know that I will be objecting to every single thing that you just said, so.
Totally should. I didn't expect to make anybody happy.
Your Honor, you can't dismiss a motion. We have not dismiss the specifications. We've not made a motion to dismiss the specifications.
And if you think I have to have motions, nothing would ever get done. I'm not trying to run this case until I think it's necessary for the court to run the case, not hear continued representations that we're going to get this thing negotiated. When I'm now at 4 months waiting for something that was inevitable that has never happened. So in my impatience, I'm going to lead. And that's how I'm going to lead. And the nice thing is I told you this 3 weeks sooner than I maybe had to. So I don't expect you to agree. You can have all the objections you want.
To disagree is what you expect. Because if you sentence the defendants, what happens legally to the state's ability to enforce their plea agreements?
Tell me why this, I know the answer, so do you. And it's found in State versus Gilbert.
Okay.
We all know
And
this.
so you're going to knowingly do that on a case where those two admitted to plotting for 4 months to kill 8 individuals, most of them while they slept.
I know the facts of the case. Thank you for the transcript. The problem is twofold.
But we're not going to trial on January 3rd then, obviously.
No, you have this.
You can't dismiss death effects without a motion by the state. When there is more than sufficient evidence to support a death penalty specification in this case, because we have got the testimony, sworn testimony of his 2 co-defendants, that he participated and personally killed 3 people. So the court has no basis to do this, no legal basis to do it.
Now, when I start talking, can we assume that you won't? I get that you're upset. You don't get that the court's been hearing representations for months about the quality of your case and the cooperation of the state's witnesses that I'm getting ready to sentence and their truthfulness, and that they're all locked in the bag, ready to go, solid case. The fact that you'll have this plea agreement worked out was supposed to have been done shortly after September, shortly after October. Every time we've met, I've asked and heard you represent, we're getting there, we're getting there. It was like somebody played a record today.
And basically what he's talking about is that Mark Collins, the attorney for Billy Wagner, and Angie Canepa kept saying they were trying to get Billy Wagner to say, yeah, I'll sign off on this or whatever. Billy wasn't signing off on anything. Billy's like, no, take it to trial, whatever. Because they wanted him to sign off on, some agreement or whatever, not a plea agreement, but something regarding the death penalty specifications. And he's like, I'm not signing anything. He's like, he's like, you want to throw me in prison, you're just going to have to go to trial.
We're getting there. Well, I'm on the tip of the spear for everything that you're not doing. So I'm telling you, we're not going forward with trial on a death penalty specification when the defense isn't ready because the state's not ready. I'm not assigning fault. I'm saying the clock ran out. The clock ran out. You know how this could play. I know how this could play. The next move is yours. I get that. I get that. I'm just telling you that we're not going to pussyfoot around any longer with assurances of things that may never happen. Oh, by the way, if you don't get your agreement worked out, we're not going to trial anyway because there's 1,000 motions that got to be decided because everybody has said we don't need all those motions decided. So I struck their motions because of your representations that we're going to get there. I get it. I'm not saying anybody did anything wrong. I'm saying the clock ran out.
Yeah.
So, do whatever you got to do. Like, I'm not going to journalize this tomorrow. The staff will go scheduling with all these guaranteed good cooperative witnesses you have lined up. And I understand what Gilbert says.
Why are you trying to sabotage this case?
I'm not.
No, yes, you absolutely are.
Okay, take the record.
If I may address that, the court by the state, Your Honor, I understand the court's frustration, but the state cannot unilaterally force the defendant to enter into an agreement when there's ongoing discussions. I think the court properly can and should set a deadline if the court wants to set a deadline, but I have never seen a death penalty expected dismissed absent the state making the request, the defense making the request. I understood at least what the court said. You have unilaterally decided because the clock ran out that you're going to dismiss death penalty specs, and I just don't think the court has that authority or has a sufficient record should an interlocutory appeal be taken to support it. And so I think I would ask that the court give the parties until, this is what day, I lose track of days, till Monday to present to the court a written agreement before the court would issue the kind of order that you just described.
You can have till Monday. And thank you for the courtesy of giving me yet another assurance. I'm working with you as much as it sounded like I wasn't. I worked with the lawyers to this point, short as it is. I get it. Everybody's been here since 2018, right? I'm the last guy on the bench, right? Criminal Rule 48B gives the court authority to announce in open court on the record the reasons for its dismissal of a case. It's an extraordinary remedy if you want to call a death penalty specification dismissal, but it's not outside the rules. I have to explain why. If I let this go longer and we don't get to the agreement, clearly anything that happens at trial is going to be reversed for all of the work that didn't get done because everybody said it wasn't. So the reason is going to be the lack of adequate time to do what needs to get done for a death penalty case to go forward. Everybody knows in the room, everybody's ineffective if this case goes to trial in January as a death penalty case. Mr. O'Brien, welcome to the party. Monday's great. Call me Monday afternoon saying we're really, really close. But at some point in time, since I've heard that for 4 months, I probably won't care. So like I'm telling you, we're out of time. I'm not taking sides except to say the system has to work. I'm not adverse to the state. I'm building this upon what I've heard for 4 months, that this isn't going to be a death penalty case. Now I have like people slamming their hands on the table, figuratively, saying that what an outrageous thing the court just did. I didn't do it. I only responded to the facts that were represented to me. Even again today, the lawyers are doing a fine job.
Okay, so he was mad. Anyway, this set the stage. Angie Canepa accused him of sabotaging her case. She filed an appeal and said this judge dismissed the death specs. He shouldn't have done it. This set the stage for this judge and Angie Canepa. She went to the Supreme Court twice, the Ohio Supreme Court, which put this guy on the case twice and said, I want him removed. He's, basically unfit. He's biased. He in favor of the defense. Her request to disqualify the judge was denied twice by the Ohio Supreme Court. So she and this judge do not get along. But yesterday, the Fourth District Court of Appeals, issued a decision on her appeal of the death specs being dismissed by Judge Hine. And basically, they reviewed the whole thing, the Fourth District Court of Appeals. They found assignments of error. The trial court erred and abused its discretion in ordering the dismissal of the death penalty specifications based in whole or in part on Criminal Rule 48B, a mere procedural rule, which as a matter of law cannot provide any substantive ground for dismissal with prejudice. And then they found a second assignment of error. The trial court erred and abused its discretion in ordering the dismissal of the death penalty specifications with prejudice and without any constitutional or statutory ground for doing so. And then finally, a third assignment of error. The trial court erred and abused its discretion in ordering the dismissal of the death penalty specifications without providing reasonable notice and opportunity to be heard to the state and the victims. So they go through this whole thing. We will go through it in more detail another time, but they go through this whole thing about why the visiting judge, Jonathan Hine, abused his discretion. So they're sending it back to him and saying, the way you did this, you can't do it. And there you have it. So everybody, I really appreciate you joining me tonight. Thank you so much. We'll get more into the Pike County case on a separate live, but that was a little bit of breaking news in that case. And I thought that I should bring the goods since we had a little bit of an Ohio night tonight. We've got some more Idaho stuff to talk about. We'll get to that another time as well, because guess what? It's just been a long, it's been a longer live tonight, I guess. Maybe I've gone longer before, but I wanted to say, everybody, thank you so much for joining me tonight. Remember, please hit that thumbs up, subscribe. I'd love to have you as a subscriber. Tell all your friends about the little channel here, and we'll continue to follow the news for you. Again, thanks so much, everybody. Have a great night. Stay warm and stay safe wherever you are. Please, stay inside and don't go out if you don't have to, if you're in the storm's path. And I will see you another time. Have a great night, everybody. See you very soon. Bye-bye.